Here at Scott Legal, we know how to navigate the often complex and daunting immigration laws to help keep families facing removal proceedings stay together to live and work in the United States. Is there any way a legal permanent resident, facing possible deportation because of a past crime, seek to have the crime forgiven to stop the deportation? Yes, a legal permanent resident facing deportation because of a past crime does have options to request an immigration judge to have a past conviction forgiven and be allowed to keep legal permanent resident status. In order to understand whether a legal permanent resident will qualify for these options, we must first understand which types of crimes make a legal permanent resident deportable. Generally, legal permanent residents are found to be deportable if they have been convicted of certain crimes. These crimes are identified as crimes involving moral turpitude if committed within 5 years after the date of admission and the potential penalty for the crime is a sentence of 1 year or longer. Convictions of 2 or more crimes involving moral turpitude at any time after admission. Aggravated felonies. Crimes of failing to register as a sex offender. Crimes involving drugs. Firearms offenses. Crimes of domestic violence, stalking, violation of a protection order, or crimes against children. You can view our video on the consequences of past criminal acts against legal permanent residents, including a more detailed discussion about crimes involving moral turpitude and aggravated felonies, by clicking the link below. The most common form of relief from removal for legal permanent residents is through the process of qualifying and applying for the waiver known as cancellation of removal for certain legal permanent residents. In order to qualify for the waiver, the legal permanent resident must prove the following. The legal permanent resident has never been convicted of an aggravated felony. The legal permanent resident has been a legal permanent resident for not less than 5 years. The legal permanent resident has resided in the United States continuously for 7 years after having been admitted in any status. Finally, the legal permanent resident must prove to the judge that she merits a favorable exercise of discretion. One important factor that is not always easy to understand is the 7-year continuous residence requirement. Accrual of the time commences after legal admission, which could be the date legal permanent resident status was granted or when any legal physical admission to the United States, such as when entering on a student, visitor, or work visa occurred. So, if an individual entered on a tourist visa 10 years ago, but acquired legal permanent resident status 6 years ago, such individual would have accrued 10 years of continuous residence status starting from the entry date on the visitor visa. However, the accrual of continuous residence can end prematurely before the 7-year period under certain circumstances. This is known as the stop time rule. The stop time rule occurs when the legal permanent resident is served with the charging document that commences deportation proceedings, known as the notice to appear, before meeting the 7-year requirement, or when the legal permanent resident has committed an offense that makes her inadmissible to the United States or deportable. Inadmissible crimes are very similar to deportable crimes, but there are notable differences. Inadmissible crimes are the types of crimes that typically disqualify a non-US citizen from being admitted into the United States, which includes being disqualified from receiving legal permanent resident status. You can learn more about inadmissible crimes by viewing our video on crimes that affect US non-citizens. Assuming the legal permanent resident meets all of the qualifying factors for cancellation of removal, the last factor the legal permanent resident needs to meet is to convince the judge that the legal permanent resident deserves a favorable exercise of discretion. This means that the immigration judge weighs the negative factors in the legal permanent resident's life, including the immigration violation that placed the permanent resident in deportation proceedings, against the positive factors in the resident's life, including any humanitarian factors, which include family ties in the United States, hardship to the legal permanent resident and family members if the resident is deported, ties to the community, history of employment, business ties, duration in the United States, proof of rehabilitation from past crimes, including the crime that places the resident into deportation proceedings. The key is to submit as much documentation as possible and to request family and friends to testify about the above humanitarian factors to convince the judge that the good outweighs the bad in the resident's life, hopefully leading to a favorable exercise of discretion, which essentially means that the judge will grant the application to allow the resident to keep her status. Approval also means that the government will not be able to deport the resident for the crimes that were at issue before the granting of the cancellation application. However, understand that cancellation of removal is only granted once, so a subsequent commission of a deportable offense will not be waivable through a second application. If a legal permanent resident has already been granted cancellation of removal or does not have 5 years as a legal permanent resident, is there any other waiver the resident can apply for? A legal permanent resident that does not qualify for cancellation of removal, but can show that she lived in lawful status in the United States for 7 years, can apply for permanent resident status known as a green card again if they have a U.S. citizen spouse or a son or daughter who can repetition the permanent resident for the green card, along with applying for a waiver of any crime that makes the non-citizen inadmissible. In this case, the legal permanent resident has lost her status by order of the immigration judge, but because of a specific qualifying family member along with a new application for a green card and a waiver of the crime, the non-citizen can reapply for the green card in front of the immigration judge. Limitations to readjusting for legal permanent resident status. Former legal permanent resident needs to prove 7 years of lawful presence before case is commenced. Former legal permanent resident cannot have been convicted of an aggravated felony. Controlled substance offenses other than simple possession of 30 grams or less of marijuana are not waivable. Note that the 7-year requirement and aggravated felony bar might not be applicable depending on the jurisdiction a legal permanent resident lives in if the green card was obtained within the United States and not through admission through a border checkpoint such as consular processing. You will need to check with an experienced immigration attorney to confirm if the bars and restrictions apply. Another common question that comes up in these waiver cases is whether a legal permanent resident convicted of an aggravated felony can still qualify for cancellation if the conviction occurred sometime in the early to mid-1990s. The answer is yes. There is another form of cancellation under a former immigration law that allows for a waiver of an aggravated felony conviction for a legal permanent resident. Note that the legal permanent resident still has to demonstrate time spent in lawful status before filing the application before the court. Also, this waiver is for convictions that occurred before April 24, 1996. Finally, it is important for a legal permanent resident with an aggravated felony to consult with an immigration attorney because there are different versions of the law with slight variations in how to qualify based on the time frame when the conviction occurred. We have new immigration videos every week. If you are new to the channel, please hit the subscribe button and bell. You can also sign up for one of our webinars, or get a free immigration guide, by clicking the link below. We are here to help. You can contact us by calling 212-223-2964 or by sending us an email. We look forward to hearing from you. You can also schedule a consultation by clicking on the link below, where you can choose a day and time that is most convenient for you.